all of you, but thanks very, very much for attending this session. I'm broadcasting from New York City, 55th and 3rd Avenue. I'm at the law firm of Mintz. Today, I'm going to talk about something a little different from the normal session. I'm not going to talk about tech. I'm going to talk more about intellectual property and how to protect your tech, and not so much about patents. I know we think about protecting tech, we think about patents, but I'm actually going to talk about trade secrets. I think it's particularly relevant to the battery space, which I've been following for the past probably about 4 years now. And for me as an intellectual property lawyer, it's super exciting to follow a technology space and an industry that really is kind of at its incipience, and how we're going to see it move 5, 10, 15 years from now. Really exciting as an IP lawyer to track that. So today we're going to talk about, and some of this might be really basic for some of you or all of you, what a trade secret is, why trade secrets are really important from my standpoint as an IP lawyer, the Defend Trade Secrets Act, which is United States specific. I'm not going to go, we don't have time to go into foreign trade secret law, like what's going on in China or the EU. And then probably most importantly, what you guys as trade secret owners can do to protect your trade secrets, prevent them from leaking out of the company. And then some examples of what we call reasonable measures, which is what the law requires you to do in terms of protecting your trade secrets. If anyone has any questions, I don't think there's like a global mute, right? Anyone can speak up at any time.
That's right. Yeah.
Okay, awesome.
It's open.
So trade secrets, what constitutes a trade secret? In the United States, it's dictated by the Defend Trade Secrets Act, which we call the DTSA. Basically, it could be anything. It can be anything, any kind of information, any kind of formula, any kind of device that provides independent economic value to the company, is not generally known outside of the company, cannot be readily ascertained, for example, reverse engineered by folks outside the company. And most importantly, you have to take what we call reasonable measures to keep the information or the sample or the device, the formula, secret. A trade secret, unlike a patent, and I'll talk about this a little bit, doesn't get a registration from the government. It's all in your hands as the company, and you can keep it secret forever. And it's will be protected and classified as a trade secret until it's no longer secret. Here's some exemplary categories. We don't have to go through all these. What I see a lot in my practice, and why I think it's particularly interesting in the battery space, is manufacturing processes. A lot of times manufacturing processes, equipment settings, chemistries, materials, types of materials, those are not things we historically have received patent protection on. A lot of times those things are difficult to patent in front of the US Patent Office, and they're better kept as trade secrets. Another issue with patents is that, guess what? When you file a patent, and if you get a patent, it becomes public. And you only have it for a limited amount of time. That's in the Constitution, and that's the exchange. We're going to give you a limited monopoly. After that's over, everyone in the world gets to use it. Trade secret's different. Like the Coke recipe, the WD-40 formulation, you can keep that secret for decades and decades and decades. Every patent starts its life as a trade secret. These are some differences between trade secrets and patents. A lot of the things I have enumerated here, I actually just spoke to. Confidential and internal. Patents are publicly disclosed. There's no eligibility issues. That's a patent nuance. A lot of times you may know software is very difficult to get a patent on in the United States because of a Supreme Court decision called Alice. You don't deal with that issue at all whatsoever with trade secrets. Trade secrets are a critical asset. I think a lot of us know this. This is a very useful graphic from Ocean Tomo that shows, generally speaking, IP, the intangibles, our intangible assets, have really increased their value and their role in the life of companies. And importantly, trade secrets are no less important than patents. They really aren't. We're going to go into why a lot, especially for early stage companies. Keeping crown jewel assets as trade secrets can be very cost effective. You immediately have a trade secret. You don't have to wait 2-3 years like you do to get a patent, and you don't have to go to the expense of trying to obtain a patent. Here's a couple reasons why and I alluded to these already, patents are not always the best mode of protection. Again, certain things are very difficult to patent, specifically in the United States. Certain technologies, again, manufacturing processes I like to refer to, are difficult to get patent protection on. And certain technologies, if they were out in the public, would be easily reverse engineered. So you want to keep them private inside the walls of the company. Manufacturing processes, again, parameters, system settings, formulations. This is an important slide, and I encourage this with and make this point with all of my clients, especially early stage companies. Trade secrets can be a very effective way to get money. Investors are looking more and more at trade secret lists, and a lot of companies are not thinking about their trade secrets enough, but they should be. A lot of times we think, okay, how do we value a company? What patents do they have? Trade secrets can be just as powerful, if not more powerful, but we have to know what they are. We have to be able to talk about them intelligently, and we have to be able to point to them on a list, what I call a registry, or some kind of recorded database where we have everything organized. Trade secrets are also the most vulnerable. Unlike patents, copyrights, trademarks, which are government protected, trade secrets are only secret until they're not. It's completely, the onus is completely on the company, and they're actually the most misappropriated IP of any of the four main IPs: patents, copyrights, trademarks, and trade secrets. Trade secrets tend to leak out of companies the most. This is particularly getting more problematic because of remote working conditions, employees moving around between companies a lot more than they historically have. The Trade Secrets Defend Trade Secrets Act of 2016. I'm not going to dwell too much on this, but it wouldn't really be a talk unless we mentioned this, unless I mentioned this in just a couple slides. So this is a very important act. Before this act in the United States came into being, before 2000, it was May of 2016, trade secret misappropriation could only be, and was only brought at the state level. There was no federal cause of action that you could bring against someone or a former employee or a company that misappropriated or stole your proprietary information. So it created a private right of action for misappropriation. And you may have seen the news. There's been, in the past 2-3 years, quite an uptick in trade secret cases, trade secret news, a lot, particularly and including in the battery space. You probably have seen headlines, some very big names involved in trade secret misappropriation, federal cases. One of the reasons we're seeing an uptick is because we see very large damage awards for actual loss, punitive damages, and attorney's fees. We can also get damages and justice for misappropriation that happens overseas. The Defend Trade Secrets Act actually covers that. And importantly, and this is really the heart of what I'm going to talk about today, the act gives companies guidance on best practices for managing and securing their trade secrets within the company. So what are the requirements under the DTSA? What do we really need to think about at a high level? Well, we need to know what our trade secrets are. We need to properly identify them. We have to protect them with reasonable measures, and we'll talk about what that is, and I'll provide some examples. There's examples later in the presentation. And then we have to, or the trade secret has to be taken or misappropriated by improper means. And that term is defined in the statute, and it actually relates to theft, bribery. It's here on this slide. Improper means theft, bribery, misrepresentation, or breach of a duty to maintain secrecy. And that includes breach of an NDA or breach of your employment agreement or a confidentiality agreement that that an employee signed. Reasonable measures, and we will go into this in more detail. Mark your documents, designate them as highly confidential. Require confidentiality agreements, have policies for handling confidential information. Very important, restrict access to certain types of information. The person in the marketing department or a person in the accounting department doesn't need to know the manufacturing process out on the manufacturing floor, and vice versa. Okay, so what can we do now to protect our crown jewels inside the company, our proprietary information? What can trade secret owners do? What can you do? The goal at a high level is to keep your trade secrets a secret. What I see most often in terms of owners, trade secret owners losing their rights, they're not able to identify specifically what their trade secrets are, and they're not organized, they're not recorded somewhere. And then therefore, if you don't know what they are and they're not organized, it's really difficult to actually protect them, specifically with what we call reasonable measures under the law. No trade secret program, a lack of adequate security and processes in place, and that leads to inadvertent disclosures. Employees accidentally tell third parties at a conference, in casual conversation at a business meeting with a vendor, specific trade secrets, and that extinguishes the trade secret protection. So if we know what our trade secrets are, we have them organized and secured, protected with reasonable measures, we can prevent them, keep them secrets and prevent them from being extinguished as a trade secret. Any questions so far?
I've got a question, Brad.
Yes, sir.
On this slide, you've got FDA submissions. I'm curious kind of how sticky that can get where the company, where the regulatory body thinks that they need that information. And yeah.
How that works actually is if you tell the FDA, if you submit a trade secret to the FDA as part of your FDA submission and you mark highly confidential trade secret, they will abide by that designation and not disclose it to outside of the FDA, and that maintains its trade secrecy under the law. Now, someone can try to undo that, a third party, if they know, they can try to undo that, but what I've seen is it's very, very difficult to file like a FOIA request or some other mechanism and get that trade secret publicly disclosed. In fact, I don't know of a case. So the short answer is if you tell the FDA, listen, this document has a trade secret in it, keep it a trade secret, they will actually do that.
Thank you.
Good question. Okay, so there's two steps at a high level, and a lot of this, again, that's why I asked Myra at the beginning, is this going to be distributed? Because a lot of this can almost, you can use going forward in the future kind of as a checklist. But there's going to be there's two steps, and I have like two steps. And this is a process that we use at Mintz. We have a program called the Trade Secret Asset Management, where we go into clients and we help them do these steps. And then they're off and on their way. We can either assist them later on, or they assign people within the company and they're off and running and they've got their trade secret program set up. Step one, we want to identify our trade secrets, and then we want to classify them. Identifying trade secrets can actually be kind of tricky. Here, what I have here on this slide 21 is you generate a list of potential trade secrets. Now, sometimes we'll go into clients, we'll go into a company, say, hey, what are your top 5 key trade secrets? What if, if an employee right now left the company, went down the street to a competitor, what are the 5 things you wouldn't want that person to take with them? And sometimes that's easy, sometimes it's not. So here's a general process that we've used. It's not the only way to do it, but it's one way to do it. Generate a list of potential trade secrets, categorize that list, identify actual secrets, create a sub list of actual secrets, and then classify those. So generating the list can be tricky because information assets, the intangibles, are seldom physical. And a trade secret portfolio is often this like cloud of information stored on paper, in cabinets, stored in this repository, stored in this other repository, and also in the minds of your employees. And employees are super key to getting your trade secret program going. And you're going to want to interview the relevant folks. And what makes it tricky is that they might not understand or know whatever is in their head, whether that's confidential, whether it's a trade secret. We see a lot of situations where someone just takes information, takes it to a new employer with them, and then they don't even realize what they did. So education, you see here on slide 23, is actually really important. We want to educate our employees. This goes for small companies, this goes for large companies, and create a trade secret culture where people are actually thinking, wait, this process, this information, this is proprietary to the company. I really shouldn't talk about it, take it with me, download it onto my personal device, my personal laptop. Then we could do this by business units. We can do it by engineering teams. And then we interview and we collect information documents from key employees. And having the documents is helpful because it helps us prove the existence, the ownership, and the value of the trade secret. So that's generating the list of potential secrets, categorizing the potential secrets. Okay, I've got all these different, say I've got 5, say one's a manufacturing process. I have here an example for disk drives. A lot of times I go, well, how do I classify this? Here, it's like a 20-page document at this one manufacturing station, or it's a 10-page protocol for formulation. This is just one suggested way of kind of thinking about your trade secret and categorizing it, dividing it up when you create a list. Then we want to identify the actual trade secrets, create the sub list. Is it a trade secret under the DTSA? And this is a list of questions. We actually see this in the case law and the court decisions quite a bit. You want to think about these are not exclusive factors, but these are some common questions that go to, all right, is this really important to the company? Have I protected it adequately? And can anybody ascertain it if it was outside the company as a reverse engineered? That really goes to defining whether or not is this important to you and whether or not it classifies as a trade secret under the law. Again, useful checklist, not exclusive, but this is a good way to think about it. This is, for example, if I'm asking you, what are your top 5 trade secrets? Let's go. Is this manufacturing process important? All right. Is it known outside the company? How many employees actually know about it? What measures have we taken to keep it a secret? All important things to think about. And then we classify it. It's important once you actually, for example, that 20-page document, once you realize that's an important trade secret with very important technology inside of it, it's got to be marked top secret, highly confidential, and then secured as well, which we'll talk about in a few slides. Register and protect. Important to understand when I say register, I don't mean register as submitting it to the federal government or submitting it to anyone. This is your own process that you can come up with. There's platforms out there, various types of platforms that we use. There's products. One that we use is called Intangibly, and you can record your trade secrets in that database, and we call that a registry. That's just kind of a common term that we use. Here's a bunch of different bullet points in terms of how to do it, how to implement protocols and databases for listing and organizing the secrets. One important thing I'll call out, this is third bullet. You want to not actually say what the trade secret is in whatever document or database that you include it in. You want to actually just describe it. For example, manufacturing process for a disk drive. You don't actually state the trade secret, the specific parameters, the secret sauce. Okay, protect. This is probably the most important. This pie chart is a good reference. This is a good way to think about the different types of protection. We have confidentiality agreements, need to know restrictions. Not everyone in the company needs to know every single key proprietary piece of information. How are you protecting it digitally? What physical measures, security measures are you using? Very importantly, when a new employee comes into the company, when an employee leaves the company, what mechanisms do you have set up? This goes a little bit into employment law, but it's part of your trade secret culture and thought process. What is a new person bringing in to eliminate any suit of infringement from their former employer? And what are people leaving my company with? Confidentiality agreements are the #1 most important piece in terms of trade secret protection and security measures. This is the baseline. If you don't have confidentiality agreements, provisions in your employee handbook, and for employees, for vendors, for third parties, for auditors, NDAs, confidentiality provisions, the courts will not say that, okay, you have not, they will not find that you've used reasonable measures to protect that particular technology. And if someone does take something, you will not have a cause of action in the United States for trade secret misappropriation without reasonable measures. Again, confidentiality agreements are the baseline. So that should always be, if you take away anything, that's your #1 security measure. They should be in writing too. No oral agreements. Need to know access. Limit access to facility areas based on job function. We've got one client that manufactures a medical device, and there's a specific step in that manufacturing process that they literally closed off, and the machine goes through into a small room. That manufacturing step happens in that room, and then it goes out the other side of the room. And to get into that room, there's a keypad, and only a handful of people in the entire company are allowed to actually get into that room. Limit access to documents and specific repositories. Third parties, this is really important. When you have visitors or when you're talking with customers, auditors, use your discretion about what you share with them, and make sure when you do share information that they're under NDA, and make sure the sharing is within the scope of that NDA. Digital security measures, a lot of these are basic, but this is a good checklist. Authentication protocols, email retention policies. One of the things we see the most in trade secret misappropriation cases is an employee downloads a large amount of information, really important documents, right before they leave or right after they get terminated from the company. And so there's software out there that can detect these kind of things and alert the company to that activity. It's also important that when you do have a termination process and offboarding process, that former employee's access to the company network is immediately cut off. Here's a checklist of physical security measures. Limit accessibility to research and production areas, which I already referred to. Limit viewership of research and production areas. If you've got a main hallway where visitors can go through, and then right through it, you've got glass and a special machine where there's a really proprietary process going on, maybe that shouldn't be set up that way, or maybe the windows should be frosted. Important things like that. Secure notebooks, lab notebooks, important papers that contain trade secrets at the end of shifts, so that people in different shifts don't necessarily have access to all those things. Know where those types of proprietary documents are at all time. Maybe you want to secure the lab notebooks in a special safe or a special lock cabinet at the end of that person's shift. And here's onboard and termination procedures. Every employee should read and sign a handbook, regular trainings. Again, this is really important to create a culture where people are actually thinking. Don't take for granted or assume that all the employees actually understand that they can't actually download or take pictures of specific things and then leave the company or walk out and take things home with them. Any questions?
I have a question about that, Brad.
Yes.
So coming from a DOE background, I had to check my phone in a lockbox before going through the gate. So I wasn't taking pictures. How do you do that? Is it just through kind of training and making people sign things so in the event that they did happen to share something or take a picture of something that got shared, they're then liable? Or how do you enforce that if not taking people's technology, I suppose?
Great question. You would enforce that with the confidentiality agreements.
Confidentiality agreements.
And,
Okay.
it's completely reasonable when you have outside people, when you have third parties coming into your facility, just we're going to go back into the manufacturing area. Keep your phones here in the conference room in the front of the office. That's fine. In restricting an actual technician or a manufacturing engineer from not having their device with them, that's probably unreasonable. I mean, it depends on the company, it depends on the employee. Each company has a different culture. But if that's not feasible, then you do it other ways, with obligations. Paper, you paper the obligations, have them sign. It's really important when an employee leaves a company, you go through what we call an exit interview, where you sit down with them in a conference room, you go through all these different things. Yes, I understand this. I've returned all my company laptop. I have no possession of anything. And then you have them sign that.
Yeah.
So then in the event that they took something unknowingly or intentionally, you have that, you send them a letter. A lot of times you can do those kind of, when things do leak out. For example, with a former employee, you can send a letter. I just did this last week, and they'll return everything, and you can work it out amicably, in fact, outside of litigation.
But the trick is having all of those pieces in place before you get to that point.
Yes. What I find to be most important for our clients and potential clients is just thinking about it. And I think people are thinking about it more. The FTC ruling with respect to non-competes have made the whole trade secret, the need for a robust trade secret program and confidentiality protocol within the company, it's made that much more acute. Usually in the past, companies solve for that with their non-compete provisions and their employment agreements. But with those going by the wayside, most likely, it's still a little bit up in the air, but we're not putting them in employment agreements as much. Protecting your trade secrets through other means, protecting information through other means, like the Defend Trade Secrets Act, is much more at the forefront. Okay, we're almost at the end here. Examples of reasonable measures. So I have a couple slides here on manufacturing because it's what I've seen the most of in my experience. I think it's particularly relevant to the battery industry. Manufacturing is a big deal in the space. Again, a lot of times it's not something that you necessarily want to patent or even can patent. The specific nuances of a particular step in the process. So I've got, what are reasonable measures? How do we take reasonable measures to protect our manufacturing process? And just here's an example of manufacturing trade secrets. Again, these are kind of best practice ideas, concepts that I've seen and used with clients. Persons with access to the manufacturing floor must have confidentiality obligations, including any vendors, auditors, customers, etc. Visitors should be accompanied by company reps. I've got some scenarios in here or case studies in a couple slides. I'm not going to go through all those, but what happens if we've got a customer coming through or another company rep coming through the facility, and they're being accompanied by a technician, and they ask the technician, hey, could I get a copy of that specification? Or could I get a copy of the materials or the bill of materials that you use. And so so a couple things. Number one, the visitors shouldn't have their phone with them. They don't, no pictures, that's a fairly standard practice. But again, the technician or whoever is guiding that person, that third party through the facility, should be educated and understand how to handle those kind of requests, and understand that those kind of documents and that kind of information should not be provided to the third party or taken outside of the facility. Here are the different case studies that I mentioned. These are additional reasonable measure ideas for research and development situations. Customer lists. Customer lists is something we see a lot of in the trade secret misappropriation arena. Those are highly, highly important often, and we want to take very important measures, rigid measures, to protect that information about customers. And software cases. Courts frequently look to, and I didn't put a lot of case citations in here. I didn't want to make it too legal, but this is a good case from the Ninth Circuit in California, who was given access to the software, confidentiality agreements for all entities, and then whether the source code was encrypted or compiled. Okay, we're at 4:25 on my watch. Do we have any